video, I would like to talk about the provisions of union territories in India. We have seen center, we have seen the states. Now, we are specifically talking about the union territories. So, the chapter heading is union territories. And we can see that it is from article 239 onwards, 239 to 241. So, now the first question is, what is the need for union territories? In fact, these are the territories of India which are directly governed by the center, directly under the center. And whereas, if you compare with the states, states enjoy autonomy, states have, constitutional powers. We have divided, there is a division of power between the center and the states. Whereas union territory means everything is under the center. There is no division, there is no, autonomy for the union territories, and directly under, but states, we know that the union list, we have then the state list, then finally the concurrent list. So, we have the divisions, say 99 items here, state list we have 61 items, concurrent list we have 52 items right now. But when it comes to the union territories, everything is union list, because it is directly under the union. Then the question is, why union territories? What is the need? There are many reasons for that. Why we have union territories? That is a question. So, there are at least 3 different reasons we can say. Some of the union territories are because of administrative reasons, administrative reasons. The best example is the National Capital Territory, that is Delhi, then Chandigarh. So, these two are created because of administrative reasons. Another set of union territories are because of cultural reasons. They are, say, Pondicherry or Puducherry. Also, now we have Daman and Dadra, Nagar Haveli and Daman and Diu. Dadra, Nagar Haveli and Daman and Diu. They are because of cultural reasons we can say. Because these territories, Puducherry was under under the French domination or the French control for many centuries. We wanted to protect their culture. Similarly, Dadra, Nagar Haveli and Daman and Diu both were under Portuguese rule for many centuries. We want to protect the Portuguese culture here. We want to maintain the identity. Small territories, we have done like that. So, Puducherry, Dadra, Nagar Haveli and Daman and Diu are because of cultural reasons. Then a third type we can say, that is because strategic reasons. See, our territory like Lakshadweep, Andaman Nicobar, okay. So, strategic reasons. We have kept these as small territories, but far away from the mainland. It is very important for us. We want to protect it, and it cannot have an independent existence because it's a small territory also, the population is also less, far away. So, because of that. Now, we have a fourth type, we can say political and historic and political reasons. That is where the Jammu and Kashmir and Ladakh, it is in the peculiar historic reasons, historic and political reasons, it is in the, we can say it is a union territory today. Otherwise, through Article 370, Jammu and Kashmir joined Indian Union, and now 370 has been repealed in 2019, and is mostly political. So, historic and political reasons. So, we have 4 different types of union territories, we can say. So, how many of them are there? The total number of union territories, Delhi is known as National Capital Territory or Delhi. Then we have Chandigarh. Then we have Dadra, Nagar Haveli and Daman and Diu, because it has been combined together. We have merged together. We have combined into one union. Earlier it was 2 different union territories. In 2019 it has merged. Dadra, Nagar Haveli plus and Daman and Diu is a single union territory today. Then Lakshadweep and Andaman Nicobar. So, 3, 4, 5. Then we have Puducherry. I just forgot to mention in between Puducherry. Then we have Jammu and Kashmir and Ladakh. Okay. So, Dadra and Nagar Haveli and Daman and Diu put together one union territory today. Now, Puducherry is another one. Even the 4 distinct units are there for Puducherry. Puducherry is there, Karaikal is there, Mahi is there. Mahi is in Kerala. Puducherry and Karaikal is in in Tamil Nadu. Yanam is in Andhra Pradesh. So, 4 different territories, but single union territory called Puducherry. Earlier it was known as Pondicherry. Then Daman and Diu and Dadra and Nagar Haveli put together, both were Portuguese territories. So, it has been clubbed together to one in 2019. I will be coming to that. So, these are the union territories we have because of various reasons. Now, coming to various constitutional provisions. In Article 239 deals with the constitutional provisions of union territories, the administration of union territories. It says Parliament by law can have an administrative setup for each union territory. Parliament by law can create administrative setup for each union territory. Okay. And it will be administered by the President of India directly, because it is a union territory, it is not under the state. So, directly under the President of India, and normally the President will appoint an administrator and he will give a designation, administrator to be appointed by the President with such designation. So, it will be administered by an administrator with such designation, that the President may specify, So, each union territory will be under the control of the President of India. President of India will appoint an administrator and with such designation as the President may specify. So, that 239 talks about who Parliament may by law can create an administrative setup, but it shall be administered under the President of India. President of India can appoint an administrator and the designation of the administrator as it is fixed by the President of India. Now, Article 239A, so there is 239A. 239A specifically talks about the creation of local legislatures or council of ministers. Creation of local legislatures and council of ministers. It clearly says that Parliament again may by law create for the union territories a local legislature. Parliament may by law can create local legislatures, legislative assemblies can create local legislatures where the members can be elected or all of them can be elected, whether there is elected or partially nominated, it can be there. There can be a there can be a legislature, local legislature for the union territory if the parliament creates. See, already under this 239A, we have for Puducherry, also for Jammu and Kashmir, we have a local legislature. Okay. So, there can parliament may by law can create local legislatures for these union territories, where these legislative assembly members, the legislative members can be either elected or some of them may be partially nominated also, some nomination also can be there, and there can be a council of ministers, and there can be a council of ministers. Again, according to Article 239A, there will be council of ministers for Puducherry, and now later on it has been added for Jammu and Kashmir also. So, these provisions, that 239A talks about creation of local legislative assemblies or legislatures and council of ministers, and based on this, now we can say for Puducherry it is very clearly mentioned, and Jammu and Kashmir has been added recently. Anyway, then 239AA, special provisions for Delhi. Now, when it comes to National Capital Territory, that is Delhi, it is under Article 239AA, and it has been clearly mentioned that Delhi will be known as National Capital Territory of Delhi. Okay, the capital of India, the federal capital of India will be known as National Capital Territory of Delhi, National Capital Territory of Delhi, and it has been, this 239AA was introduced through 69th Amendment Act 1991. It was through 69th Amendment Act 1991. It was through 69th Amendment Act 1991. And there shall be, and it is also mentioned that Delhi will be under the administrator, an administrator will be known as the Lieutenant Governor. Okay. The administrator of Delhi, according to 239AA, will be known as Lieutenant Governor. Okay. Lieutenant Governor. Okay. So, the administrator of Delhi will be known as Lieutenant Governor. 69th Amendment Act, Delhi will be known as National Capital Territory of Delhi, and there shall be legislative assembly, and it will be direct elections will be held, and there will be a legislative assembly of 70 members. 70 members legislative assembly will be there. So, there shall be a legislative assembly for the National Capital Territory, and the seats in the assembly will be directly elected, and a 70-member legislative assembly will be created, and it will be, and that has been, it will be regulated. The number of the members of the legislative assembly will be regulated by the parliament. Regulated by the parliament. It is very clearly mentioned, Article 239AA, and the number of the legislative assembly members will be regulated by the parliament, and there shall be a council of ministers. There shall be a council of ministers with not more than 10% of the total number of the legislative assembly, not more than. So, not more than 10% of the total strength of the legislative assembly. Not more than 10%. See, please remember, for the states, the total strength of the council of ministers can be 15%. 15% of the strength of the legislative assembly, but here it is 10% only. Okay, there can be 10% of the strength of the legislative assembly, and it will be headed by a chief minister, and the lieutenant governor, the chief minister, aid and advise. Okay, it is very clear, chief minister as the head to aid and advise the lieutenant governor. The CM will aid and advise the lieutenant governor. And lieutenant governor. So, the chief minister will aid and advise the lieutenant governor, and the lieutenant advise the lieutenant governor in the exercise of his function. Naturally, in relation to the matters with respect to the to which legislative assembly has the power, and except even lieutenant governor, like governors can need not follow, except in so far as where he is by under any law, he is required to act in his discretion. So, even the lieutenant governor has discretionary power. Lieutenant governor has discretionary power. Okay, the way governors have discretionary power, even lieutenant governors have discretionary power, and in case of a difference of opinion between the chief minister and the lieutenant governor, okay, and there shall be, it can be, lieutenant governor shall refer it to the President of India for the decision. If there is a difference of opinion, very important, which is not the case with the state governors. State governor, if there is a difference of opinion between the council of ministers and the governor regarding anything is under his discretionary power or not, that the governor's decision under his discretion is final. But here, if there is a difference of opinion between the lieutenant governor and the ministers on any matter, the lieutenant governor shall refer it to President of India. The LG shall refer it to the President of India. It is a very important difference. LG shall refer this matter. If there is a, I am repeating this, if there is a difference of opinion between the lieutenant governor, LG and the council of ministers on any matter, then the lieutenant governor, LG shall refer it to the President of India for a decision and act according to the decision given by the President of India. So, it has to refer to the President of India, and the President will advise, President will tell what is to be done. And please note one more point, the Chief Minister of Delhi is appointed by the President of India, not Lieutenant Governor, very important. The CM of National Capital Territory of Delhi is appointed by the President of India. Okay. It is not appointed by the Lieutenant Governor, and the other ministers shall be again appointed by the President on advice by the Chief Minister. So, please note the Chief Minister of the National Capital Territory of Delhi is not appointed by the Lieutenant Governor, it is appointed by the President of India, and the President will appoint other ministers on an advice by the Chief Minister. Okay. And the Council of Ministers shall be collectively responsible to the Legislative Assembly. That is the same. The Council of Ministers are collectively responsible to the lower house, that means the Legislative Assembly, okay, to the Legislative Assembly, no problem. That is same as that of the states also. Okay. So, these are some of the provisions of Article 239 AA specifically for Delhi. Then there is Article 239 AB that deals with provision in case of failure of the constitutional machinery. Provision in case of failure of constitutional machinery, if the President on receipt of a report from the Lieutenant Governor, and if he or otherwise if he is satisfied that the situation in the national so this is specifically about the failure of the constitutional machinery for Delhi. 239 AB is specifically for Delhi. If the President of India is satisfied that that the situation in the National Capital Territory cannot be or the administration in National Capital Territory cannot be carried in accordance with the provisions of 239 AA, or any of the provisions in that article, the President may by order suspend the operations of the Article 239 AA. So, if President of India feels that the administration cannot be carried in accordance with the provisions of the Constitution, the President may suspend Article 239 AA, so that the Chief Minister can be dismissed. The meaning is the President may order suspend the operations of any provisions of Article 239 AA. That means the President can suspend this 239 AA means he can take over the administration completely. He can dismiss the state government if required. That means he dismiss the National Capital Territory government if required. Okay, so that is about the 239 AB. If the provision in case of failure of the constitutional machinery, that means the President of India can dismiss the Legislative Assembly as well as even the Chief Minister, that is the meaning of it. Then Article 239B. This deals with the power of the administrator to promulgate ordinance during the recess of legislature. Okay, the power of the administrator to promulgate ordinance. That means in Delhi as well as in Pondicherry, very clearly mentioned, for the Union Territory of Puducherry as well as for Delhi, there the administrator can promulgate ordinance when the Legislative Assembly is not in session. When the Legislative Assembly is not in session. So, this is again it will be applicable for Jammu and Kashmir also, because see about Jammu and Kashmir we do not know much, because there is no assembly right now, everything is in a mess, it has been done in a hurry, lot of confusion is there, but this will be applicable to Jammu and Kashmir also as and when it is required. So, when the Union Territory or when the administrative, if the Legislative Assembly is not in session, whether it is Pondicherry, whether it is Delhi, whether it is for Jammu and Kashmir in future, the administrator can promulgate ordinance as the circumstances appear to him require. Okay. So, basically the administrator can promulgate, that means Lieutenant Governor in all the cases, LG can promulgate ordinance if the Legislative Assembly is not in session, provided that no such ordinance shall be promulgated by the administrator except after obtaining instructions from the President of India. The only condition, 239B, the only condition, that means the Lieutenant Governor in Pondicherry, in Delhi and in future in Jammu and Kashmir also, they can, the Lieutenant Governor can promulgate ordinance like the Governor can promulgate ordinance, but the only difference here is only after obtaining instructions from the President of India. So, two things are there to promulgate 239B, two things are there, 239B once again, two things. One is when the Legislative Assembly is not in session. One, Legislative Assembly is not in session. Number two, after obtaining instructions from the President, very important, instructions from the President. After obtaining instructions from the President, not opinion at all, instruction. The word mentioned in the Constitution is instruction. So, the administrator can issue ordinances like governors when the Legislative Assembly is not in session and only after obtaining instructions from the President of India. And also, there cannot be no ordinance if the Legislative Assembly is dissolved. That is also very important. No ordinance, 239B says, no ordinance by LG or administrator if the legislature is already dissolved. See, this is not the case with the states. Even when the parliament is dissolved, the President of India can issue ordinance if required. But in the case of the union territories, especially where there is a legislative assembly or a legislature, the Lieutenant Governor, the administrator cannot issue ordinance, it is very clearly said that wherever the said legislature is dissolved or its functioning remains suspended on account of any action taken, then the administrator shall not promulgate any ordinance during such period of dissolution or suspension. So, no ordinance by LG if the legislature is already dissolved. Okay. So, these are the, so 239B, very interesting, the power of the administrator to promulgate ordinance when the legislative assembly is not in session, and number 2, he can issue ordinance only after obtaining instruction from the President of India, and number 3, no ordinance by Lieutenant Governor if the legislature is already dissolved. Okay. So, that is about 239B. Then Article 240. Article 240 deals with the power of the President to make regulations for certain union territories. Power of the President to make regulations for certain union territories. So, here we are talking about the President the President of India may make regulations for peace, progress and good governance. For peace, progress and good governance or good government of the Union Territory of Andaman Nicobar, Lakshadweep, Dadra Nagar Haveli and Daman and Diu, Puducherry, all the Union Territories, there can be the power of the President to make regulations for certain union territories. So, the President can do time to time he can come up with the new regulations for peace, progress and good governance. Okay. So, all the union territories he can do regulations, he can make regulations for peace, progress and good governance. So, that 240 is a general one, nothing to worry, and 241 deals with the high courts. Article 241, it deals with the high courts. It clearly says the high court for union territories, Parliament may by law constitute a high court for a union territory and declare any court in any other such territory to be a high court for that territory also. See, Parliament may by law create a high court for a union territory. There is a problem in that. Okay. So, we already have under 241, we can see this Delhi has a high court. It was a union territory right from the beginning, Delhi has a high court. Now, even Jammu and Kashmir has a high court, separate high court, Jammu and Kashmir high court is there. So, this provision 241 deals with the high court, and if there is no separate high court, these union territories will be clubbed with a nearby high court. For example, Andaman Nicobar is with the Calcutta High Court. Puducherry with the Madras High Court. Then we have Daman and Diu and Dadra Nagar Haveli, it is with the Bombay High Court. We have in Jammu and Kashmir, it has a separate high court, Jammu and Kashmir High Court. Now, Ladakh, it has Jammu and Kashmir High Court. Chandigarh, it is with the Punjab and Haryana High Court. Chandigarh with the Punjab and Haryana High Court. So, Lakshadweep with the Kerala High Court, I just forgot to mention Lakshadweep. Lakshadweep with the Kerala High Court. So, Article 241 says that the Parliament can make provisions for a separate High Court, may by law constitute a separate High Court for a union territory, or it can be clubbed with the union territory or other clubbed with a High Court of that locality or other in that vicinity, whatever it is. Okay. So, there is a provision for that is 241, Article 241. Okay. So, that is about 239 to 241, these are the provisions, but two things happened in 2019, two developments as far as the union territories are concerned, two developments in 2019. One, Dadra Nagar Haveli and Daman and Diu were merged together to form a single union territory in 2019. It is known as Dadra Nagar Haveli and Daman and Diu Merger Bill, Merger Act. Dadra Nagar Haveli and Daman and Diu Merger Act 2019. Dadra Nagar Haveli and Daman and Diu Merger Act 2019. So, these two union territories were merged, okay, in 2019, and it got, in fact, if you look at the Dadra, and that is in 2019. So, if you look at this, Dadra and Nagar Haveli, they got independence from Portuguese in 1954. Portuguese for independence got 1954, and Daman and Diu got independence in 1961. It was liberated, the union territory, or rather subsequently it was merged with the, in 1961, after Daman and Diu was also liberated. Both of them, 1961 Daman and Diu was liberated, Dadra Nagar Haveli got independence in 1954. Okay. So, both of them became a union territory, separate union territories in 1961. Okay. Both of them were part of, in 1961, it became part of Goa, Daman and Diu one, and the other one in 1961, plus in 1961 it also made the Dadra Nagar Haveli as a separate union territory. So, two union territories were created in 1961. Then again in 1987, Goa became a state. Goa was converted into a state. Then Daman and Diu and Nagar Haveli became separate union territories at that time. Okay. So, in 1987, Daman and Diu became a separate union territory. Dadra Nagar Haveli became a separate union territory. I mean, it was already there right from 61. Then finally, in 2019, the merger bill, Daman and Diu and Dadra Nagar Haveli, and the merger finally came into being, the combined union territory came into being on 26 January 2020. This new UT called Dadra Nagar Haveli and Daman and Diu. Okay. This new union territory called Dadra Nagar Haveli and Daman and Diu, that came into being on 26th of January 2020. And this merged union territory, this merged union territory has, because of the merger, it amended the first schedule. Please remember, when a new two union territories have been merged to a single one, first of all, because of this, amendment act, number one, the first schedule was amended. First schedule amended. Because in the first schedule, okay, in the first schedule, earlier what is there? In all the union territories are separately written. Daman and Diu was separate, Dadra Nagar Haveli was separate. Now it is a combined one name has come, so the first schedule has been amended. Then also, this has also led to another change, that is Article 240, where the President of India may take steps for the good governance and the smooth function of peace, progress. Okay. There also very clearly the name has been clubbed together. So, there is an amendment in article 2nd, article 240, changes were made. Changes were made means earlier very clearly mentioned Dadra Nagar Haveli and Daman and Diu, it's combined together, it has made one. So, President may take appropriate action for peace, progress and good governance of some of the union territories. Then number 3 change is, so 240 also, see, but please remember, this does not require Constitutional Amendment Act. It is any change in the name or merger and all those things, like reorganization of the states only. So, it is only a bill, or rather it is only an ordinary law. It is not a constitutional amendment law, please remember. So, first schedule amendment, no need for constitutional amendment. And in 240 also, the name of the union territory has been changed, no constitutional amendment is required. And one more change because of this is the representation of the union territories in Lok Sabha. Representation in Lok Sabha. See, till now, Daman and Diu had one seat, Dadra and Nagar Haveli had another seat. So, now this combined union territory will have 2 seats. Okay. So, the representation, there is no change as such, but we have to say that now Daman and Diu plus Dadra Nagar Haveli has 2 Lok Sabha seats. Earlier, Daman and Diu had 1, Dadra Nagar Haveli had another 1. Now, these two put together, there are 2 seats. So, there is no change. But now, whenever we talk about the number of Lok Sabha seats from this particular union territory, we will say there are 2 Lok Sabha seats from Daman and Diu plus Dadra Nagar Haveli. So, it is a small region, so 2 Lok Sabha members are there now. But some of the big states, like the population of these states are too less. And even then, this union territory is too less, but still they have 2 union territories, so 2 Lok Sabha members are there. So, that is a good thing for them. Okay. And the jurisdiction of the combined union territory, Daman and Diu and Dadra Nagar Haveli, it is again the Bombay High Court only, no change in that. The Bombay High Court will continue to be have the jurisdiction over Daman and Diu and Dadra Nagar Haveli. So, these are the broad changes which took place, which came into being on 26 January 2020. So, this is one big change happened in 2019. Another is the Jammu and Kashmir Reorganization Act 2019. The second change of 2019 is Jammu and Kashmir Reorganization Act 2019. The whole thing started in August 2019, and Jammu and Kashmir Reorganization Act, it divided the state into 2 separate union territories. First of all, in this act, Article 370 was abrogated, Article 35A, where it used to provide for the provision of permanent resident status for certain people. This 370, the special status for Jammu and Kashmir, 335A, where it provided permanent status, permanent resident status for certain people. The people of Jammu and Kashmir were given the permanent resident status. So, these 2 were abrogated and has been removed, and then this Jammu and Kashmir, what has happened? It has brought in Jammu and Kashmir Reorganization Act 2019. Jammu and Kashmir Reorganization Act was passed, and based on that, there is Jammu and Kashmir and Ladakh, 2 the Jammu and Kashmir Reorganization Bill or other act was passed in August 2019, and it is piloted by the Home Minister Amit Shah at that time. And the Union Territory of Ladakh, now a new Union Territory has been created. This Union Territory of Ladakh has 2 districts, Kargil and Leh districts. Kargil and Leh districts will be there, and the Union Territory of Jammu and Kashmir will comprise the remaining territories. Okay. Jammu and Kashmir, the remaining districts. And Assembly of the Jammu and Kashmir, the reorganization bill, so there will be an assembly, there will be Jammu and Kashmir assembly for Jammu and Kashmir. Ladakh has no assembly, only an autonomous region will be there. And now the total number of legislative assembly members will be 107 in Jammu and Kashmir, out of which 24 will be remaining vacant, 24 seats vacant. This is kept for POK, seats vacant, which is reserved for Pakistan occupied Kashmir. So what is left is 83 seats in Jammu and Kashmir. This union territory, there will be 83 seats. Earlier, when both were there, when the Jammu and Kashmir state was there, I think they used to have 87. So 4 seats have been reduced. Why? Because that 4 seats area has gone to Kargil, I mean that Ladakh region. So that is how it has been reduced from. So the total number of seats will be 107 in Jammu and Kashmir. Okay, 107 in Jammu and Kashmir, out of which 24 seats will be remaining vacant. That is for POK, that is the provision given. And also, in addition to this, the Lieutenant Governor can nominate 2 women members. Okay, 2 women members can be nominated. So this is something very important. If the governor feels that there is no adequate representation of women in the Jammu and Kashmir Assembly, 2 women members can be nominated. And also, there will be some seats can be reserved for scheduled castes and scheduled tribes, which is not there earlier. Some seats can be reserved for scheduled castes and scheduled tribes in the Jammu and Kashmir Assembly. Some seats will be reserved for scheduled castes and scheduled tribes in proportion to their population in the union territory. So, of course, in the Jammu and Kashmir Assembly in proportion to their population. So, this is something which was not there earlier. So, there will be provision for reservation of scheduled castes and scheduled tribes in the Jammu and Kashmir Assembly in proportion to their population, that is also there. And another big change brought is the tenure of the Legislative Assembly has been reduced to 5 years instead of 6 years, which was there earlier. Okay, the tenure of the Assembly is reduced to 6 years, reduced to 5 years instead of 6 years. Okay, to reduce to 5 years instead of 6 years. So, till now, before the abrogation of Article 370 till 2019, the tenure of Jammu and Kashmir Assembly was for 6 years. Now, it has been reduced to 5 years, and the governor has a lot of powers. Okay, and that means the union territory of Jammu and Kashmir will be administered by the president, and the administrator will not be, no more governor, no governor for Jammu and Kashmir, will be lieutenant governor, no governor, only lieutenant governor, or only LG will be there. Okay, so everything will be appointed, or rather it will be done through LG, and most of the provisions of the Jammu and Kashmir Assembly now will be almost similar to what is there in Delhi, and the Council of Ministers will have 1/10. The Council of Ministers strength will be 1/10 of the Legislative Assembly strength. Okay, so and then also, as far as the state list is concerned, state list has become any matter specified in the state list except police and public order will be there with the Legislative Assembly. So, any matter in the state list except police and public order So, police and public order will be with the union, will be with the Lieutenant Governor. The Chief Minister will have all the, or the Legislative Assembly will have power on all matters related to the state list except police and public order. Okay. So, and otherwise the Parliament can make laws in the union list as well as even in the concurrent list, the way which is functioning for the other things. But here the most important thing is the state list matters are given. So, the Parliament will have the power to make laws in relation to any matter for the Union Territory Jammu and Kashmir like any other Union Territory. And as I told, the Council of Ministers will be 10% of the strength, 1/10 or 10% of the strength of the Legislative Assembly. The Chief Minister will have to communicate all decisions of the Council of Ministers to the Lieutenant Governor, and there will be a common High Court for Jammu and Kashmir and Ladakh, and there will be a High Court, and that is the concession the government has given, and also there will be an Advocate General for Jammu and Kashmir. All these things are there, but otherwise Jammu and Kashmir, which enjoyed maximum autonomy, which negotiated their autonomy before joining Indian Union, has been reduced to an union territory. It is not even a state today, and that too without any consultation with the people of Jammu and Kashmir, without any democratic process. Even in the Parliament, the whole bill, reorganization bill, was passed overnight, 48 hours, both Lok Sabha and Rajya Sabha passed it without any discussion, without any proper discussion. And most of the Jammu and Kashmir leaders were sent to jail. India has sent almost 3 lakh additional, or rather total 3 lakh policemen and army men in Jammu and Kashmir to protect, or rather to ensure that the people are under control. Just see, under police power we are holding this. In a true democracy, we cannot be doing this. In a true democracy, we want the people should feel part and parcel of the country. We should feel good, and every citizen should feel good and proud to be an Indian. And the big question mark is, the outsiders are deciding about how Jammu and Kashmir should behave and everything. It is quite unfortunate. They have big history, but we need to bring the people of Jammu and Kashmir as true Indian. They should feel for India. They should feel part and parcel of India. That should be our goal. That is what every government should be trying, and the people should be consulted. And there is a political issue. There are a lot of, this is historic baggage is there, and there should be consultation. There should be democratic process, and the human rights of the Jammu and Kashmir people should be protected at any cost. The rights are very important. We cannot take away the lives of the people. We cannot take away the rights of the people. No internet, nothing. It is a very sad aspect of our country today. We can always say Jammu and Kashmir is a part of India. Geographically it is true, but are the people feeling really part of India? It's a big question mark. So, we have reorganized without any consultation, without any people's participation. We have forcefully decided something from Delhi, what is good for Jammu and Kashmir. We may say, as an outsider, people from other states will say that is good, but it should be good for the people of Jammu and Kashmir also. They also should feel good. But that is not the case right now. Anyway, so these are the union territories in India, and there are the provisions right now. So, in 2019, 2 big changes took place. One, Daman and Diu and Dadra and Nagar Haveli merged together to form one union territory. Then, unfortunately, we have abrogated Article 370, Article 35A has been removed, and Article 35A specifically talked about the permanent residence qualification for the people of Jammu and Kashmir. It has been removed, and Jammu and Kashmir has been reduced to a union territory, and the state has been bifurcated into 2 states, or into 2 union territories, one Jammu and Kashmir, another is Ladakh. So, that is all about union territories.